We're going to be looking at the case of Wholesale Sand and Gravel Incorporated versus Decker, a 1993 case from Maine. The right of a victim of repudiation to act on the obligations set forth in a contract is no longer subject to question under most circumstances, but the difficult issue in contemporary law usually involves the more subtle question of what constitutes a material repudiation, especially when the apparent intent not to perform is gleaned from an unclear statement or conduct. This presents a hazard to the party who, believing that the other party has repudiated, declares an advance breach and cancels the contract. If she was wrong in her interpretation of the words or conduct, she may herself have repudiated the contract by canceling it. So you see the risk here. In the case of Wholesale Sand and Gravel, the judgment was entered in the Superior Court in favor of James Decker. Decker claimed breach of contract. Wholesale contended that the court made a mistake in holding that its conduct constituted an anticipatory repudiation. Well, what happened here? Wholesale agreed to install a gravel driveway on Decker's property. Well, that doesn't sound like too much of a big deal. The contract included no completion date, but it did say that payment was due within 90 days. So Carl Goodenow, Wholesale's president, says that he believed he had 90 days within which to complete the contract. It doesn't sound too sensible or reasonable to me. So he told Decker that he would complete the contract, complete the work, within a week. Now that makes sense. Well, he started and then the ground was too wet, so he had to delay. So he delayed and he delayed because the bulldozer that he was using got stuck in the mud and other problems like that. So let's see. He decided to wait for the ground to dry out before proceeding further. So there was no activity for about a month in June and July. So Decker contacted Goodenow and said, "Hey, what's up? Let's get back to work here." "Get right on it," he said. So he called him again and he said the same thing. He called him again, he said the same thing. Well, at this point, whatever it is, Goodenow still believed that he had 45 days within which to complete the contract. Remember, that's based on the 90 days within which to pay that Decker had. Well, that's not what Decker believed, because he went ahead and hired another contractor who finished the job. Later, of course, Wholesale sued, saying, "We want damages. You should have paid us for doing the job." And the trial court entered a judgment in favor of Decker. That is, there was anticipatory repudiation. So this appellate court finds that Wholesale's conduct constituted an anticipatory repudiation and that Decker was okay doing what he did, calling an end to the contract. Now, Corbin defines an anticipatory repudiation as follows. It's a definite and unequivocal manifestation of intention on the part of the repudiator that he will not render the promised performance when the time fixed for it in the contract arrives. Well, this court says, yeah, that's what happened here. Look, we look at several different items of evidence to determine that. First, Wholesale removed its equipment, never brought it back. Second, Goodenow, the president, said several times, he promised to get right to work but didn't do so. And third, when Decker was confronted with the fact that Wholesale would be fired if he didn't appear at the job on the following day, which is different than the other times, really, Goodenow promised he'd be at the site right away. Next day, I think. Yeah, never showed up. So, on that record, the court held it was reasonable for Decker to believe that the contract had been repudiated and that the company would never complete its performance. Therefore, the judgment is affirmed. Now, there is a dissent, and Wathen, the chief judge, dissented, and he said, in his opinion, the record is devoid of the following: direct, unequivocal, absolute evidence of a refusal or inability to perform. So you see, the justices who were with the majority opinion believed that the acts of Wholesale were enough to allow Decker to reach that conclusion, and they upheld Decker's belief that the contract had been repudiated. But the Chief Justice said, no, you got to have the direct, unequivocal and absolute evidence, or a refusal, or perhaps an inability to perform. So that gives you a difference of opinion there. Fortunately for Decker, the opinion of the majority was in his favor.